Welcome to the PSL Property Audio Update for August 2016. I'm Eleanor Clark and I'm a commercial property lawyer working in Lexis PSL's property team. This month's highlights include cases on the right to develop versus the right to manage, business rates, capital allowances and service charges. The right to develop versus the right to manage. In Francia Properties versus Aristu, the court considered the question of whether a landlord's right to redevelop property conflicted with the right of a right to manage company to manage the building under Part 2, Chapter 1 of the Commonhold and Leasehold Reform Act 2002. This important case concerned the competing rights of landlords and right to manage companies. The landlord intended to develop the roof of the building by adding an additional flat. The question of general interest is how the conflict between a landlord's right to develop its retained property and the exercise of management functions acquired by a right to manage company under the Commonhold and Leasehold Reform Act should be resolved. According to this decision, neither landlords nor right to manage companies have untrammelled rights. The court found that the landlord was entitled to carry out the development and that the Commonhold and Leasehold Reform Act did not prevent a landlord building on its retained property where a right to manage company had acquired the right to manage, provided the landlord took all reasonable steps to minimise the disturbance to the management functions of the right to manage company, both during and after the works. It is unclear how the decision would be applied in other cases. It is a county court decision, which is not a court of record, and so of limited precedent value. However, it is the first known decided case on this issue. Because the decision raises an important point of principle, the judge granted permission for a leapfrog appeal straight to the Court of Appeal. Business rates. Following the Supreme Court decision in Woolway versus Mazars, the way the Valuation Office Agency values non-domestic buildings which are occupied by more than one person or a business could mean a change in business rates for some ratepayers. Prior to this ruling, valuation officers had for some years adopted the practice of treating separate but adjoining areas occupied by one individual or company as a single property. The rateable value of one merged unit can be less than the total value of the two or more individual units, therefore saving the occupier money. However, they will now be obliged to treat different areas of the same building, which are accessed through communal areas, as separate premises for business rate purposes. The court changed the law and taxpayers are left with retrospective liabilities for which they have not budgeted and cannot budget because the taxing authority cannot stipulate what the amount of the extra liability is until they have reviewed each property. Capital allowances. In Wellstead versus HMRC, a company was entitled to capital allowances on acquiring an interest in a property. The first-tier tribunal decided that it had acquired a relevant interest in the property in order to qualify under the legislation, despite the fact that it had only been granted an underlease. The facts contain an important lesson. The manner in which a property transaction is carried out can have important knock-on implications for tax purposes. In this case, the dispute, which took some 12 years to resolve, only arose because a factory was purchased by way of underlease rather than petition and assignment of a head lease. Thankfully, the tribunal took a common-sense approach and decided that the issue should not turn on conveyancing niceties, but this very much depended on the construction of the legislation which appeared to allow for such an approach. Service charge roundup. 4 recent tribunal cases deal with different aspects of the residential service charge recovery. The cases make clear that, following leaseholders of Foundling Court and O'Donnell Court versus London Borough of Camden, it is the landlord intending to carry out the works triggering the statutory service charge consultation requirements, here the superior landlord, who has the duty to consult, and it must serve notice on all of its tenants and subtenants regardless of the practical difficulties in knowing the identity of those tenants with whom it was obliged to consult. Following Cannon versus 38 Lambs Conduit, under the statutory service charge regime, if service charge is legally due, the tenant cannot evade liability where the landlord has failed to serve a valid demand. The landlord can rectify this. Following Avgarsky versus Alphabet Square Management Company, the first-tier tribunal, having found that the method of calculation of service charge was unfair, should have required the landlord to recalculate the service charge for previous years and not just going forward. Following Sinclair Gardens Investments Kensington versus Avon Estates London, The wording of a lease must be clear and unambiguous to allow for the recovery of the costs of legal proceedings. And finally, following 23 Dulces Avenue, 1998 versus Vajdani, the £250 recovery limit for residential service charges, where the statutory consultation requirements have not been complied with, does not apply to payments requested in advance of the works. It was open to the landlord in question to correct the lack of compliance, here insufficient estimates because they included details of additional works. The statutory limit only applies to claims where work has been carried out and the consultation requirements have not been complied with. The failure to comply with the consultation requirements may be relevant to the reasonableness of the amount to be paid under the Landlord and Tenant Act 1985, Section 19.2, as advance service charge. However, it is simply a factor to be taken into account. Thank you for joining us for this PSL property audio update. We hope you found it useful and will join us again next month.